Hello guys, my name is Melcher Villalobos. You call me Sme. I'm the last reporter. Wherever you guys are, morning, afternoon, or evening, while studying, you needed to. And when I'm the last report, and then this is my title: the government regulation and legal aspect of strikes, conciliation and mediation. It's a Republic Act number 62715. An act extended protection to labor, strengthened constitutional rights of workers to self-organization, collective bargaining, peaceful concerned activities, foster industrial peace and harmony, promote preferential use and voluntary modes of settling labor dispute, and reorganize the National Labor Relations Commission, amending for these purposes certain provision of Presidential Decree number 442 as amended, otherwise known as Labor Code Philippines, appropriating funds therefore and other purposes. Before we go to the other topics, take time and read the definition terms because maybe you don't know the meaning of the other terms. Employer, you know what it means, it's literal. As, as it's discussed from the other reporters, employee, labor organization, and legitimate labor organization. And now, these terms are the company union. It's an organization formation within the labor practice code. These terms will be again and again. It will show to the upcoming topics again to the other articles. Voluntary arbitrator means a such any person named or designed in collective bargaining agreement by the parties to act their voluntary arbitrator. One chosen or without assistance National Conciliation and Mediation Board, NCMB for short. First, selection procedure agreed upon the collective bargaining agreement or any official may be authorized by Secretary of Labor and Employment to act the voluntary arbitrator upon the written request agreement parties to a labor dispute. Now here, a strike means a temporary stoppage of work, like a no work actually. You know what I mean? The word close office, close food stalls, they will strike upon. Lockout means temporary refusal or employer to furnish the work as a result of industrial labor dispute. Internal union dispute includes all dispute or grievance arising for any violation, disagreement over any provision of the Constitution by laws of the Union, including any violation of the rights and condition Union membership provided for its discode. Strike breaker means any person who obstructs, impedes, or interferes with by the force, violence, coercion, threats, or intimidation any peaceful picketing by employees during any labor controversies affecting the wages, hours, or condition of work, or any exercise right of self-organization or collective bargaining. Strike area means an establishment, warehouses, depots, plants, or offices, including the sites of premises used runaway shop of an employer struck against, or as well in the immediate vicinity actually used on picketing strikers in moving to a row before all points of entrance to exit from said establishment. This is the start of my report. Just try from from Dole. The title is number 8, strikes and lockouts, and foreign involvement in trade and union activities. That's where you can find all the information about my report on the said manual. Take note that strike is the most powerful weapon for the working class. Before we go on strike, guys, and in the working class, especially us, the working class, in the future, just request the requisite and go to your goal of strike, because if the strike failed upon the goal, you will be fired upon the job. Now let's go, guys, to the article of the regulatory or requisite of the valid strikes. Okay, Article 263. It is a policy of state to encourage free trade unionism and free collective bargaining. B. Workers shall have the right to engage in a concerted activities for the purpose of collective bargaining or for their mutual benefit and protection. The right legitimate labor organizations to strike and picket and of employers to lock out are consistent with the national interest shall continue to be organized, respected. However, no labor union may strike and no employer may declare a lockout on grounds involving interunion and interunion disputes. C. In case of bargaining deadlocks, a duly certified or recognized bargaining agent may file a notice strike, or the employer may file a notice of lockout with the ministry at least 30 days before intended date. Thereof, in any case an unfair labor practice, the period of notice shall be 15 days, and in absence of a duly certified or recognized bargaining agent, the notice strike may be filed by any legitimate labor organization on behalf of its members. That meaning employees on your union on that company. However, in any case, dismissal from employment of union officers duly elected in accordance with the union constitution and bylaws, which may constitute union busting where existence of the union threatened, and the 15-day cooling off period shall not apply. The union may take action immediately. Amended by the Executive Order number 1112, December 24, 1986, approved. To get a strike, you take note this is very important, that a valid ground for a strike will three things: a bargaining deadlock, unfair labor practice, and union busting. Union busting is a dismissal from an employment parang ganito lang, guys. Dismissal lang siya ng employment, yung union officer ninyo, doon na yung union busting. Parang threatened na yung union ninyo dahil dinidismiss na ang officer ninyong isang officer ninyo. Kasi doon na kapag gano'n nangyari, meron na magiging problema. Kasi nga siya yung officer ninyo, siya yung nagli-lead for any problems to go on a strike. Kapag nangyari yon, lagot na kayo kasi nga mahirap nang gumawa ng officer ulit kapag malalaman na. Although, yung pag na-dismissal ng officer ninyo, di naman talaga siyang discriminatory, especially may ginawa ang officer nyong hindi maganda. Committed an act of a misconduct, In any case, if the officer is or union officer is fired with no intended misconduct, yun na yung case na ito. Ito na yung kailangan nyo na take action. Nare-threaten na kasi kayo. Next, D. The notice must be accordance with the such implementing rules and regulation at the Minister of Labor and Employment. Okay. During this calling off period, it shall be the duty of a ministry to exert all efforts and mediation, conciliation to effect the voluntary settlement. Should the dispute remain unsettled until the lapse of requisite number of days from mandatory filing and the notice, and the labor union may strike or the employer may declare a lockout. So, balik tayo dito. Dito guys, ito dapat bargaining deadlock, lockout, yan, labor practice, union busting. Ito, dapat may notice, pupunta tayo sa NCBA, yung, ano nyo, filed NCBA, a filed notice to make a strike. Notice of strike is within 30 days. If it is bargaining deadlocks, 15 days is unfair labor practice. And the union busting will be a none. No need to notify. It's a union busting, guys. No need to report to the NCBA. It will take action immediately to the next day. Or not, I guess so. Union busting will be act immediately. Notify, report it immediately so it can be approved immediately. And make a vote, before that, make a majority vote for a strike vote within the union. And now we're here, as I say, from the other articles, letter C and D, there should be a secret meeting within the union. Katulad sinabi ko kanina, a decision to declare a strike must be approved by a majority of the total union membership in the bargaining unit concerned, obtained by the secret ballot meetings, referenda called for that purpose. A decision to declare a lockout must be approved by the majority, the board directors of the corporation or association or the partners in the partnership, obtained by the secret ballot meeting called off for that purpose. The decision shall be valid for the duration of dispute based on the subjectively same grounds considered when the strike or lockout vote was taken. The ministry may, its own initiative or upon request of any affected party, supervise the conduct of the secret balloting. In every case, the union or the employer shall furnish the ministry the result of the voting at least 7 days before the intended strike or lockout, subject to cooling off period herein provided. Yung cooling period na to, guys, cooling period is a purpose, yan, is designed, how many days again? Wait, sorry. Cooling period is a 15 days to a 30 days cooling period, designed to be parties that will be mediate with the NCBA to undergo a strike or not. Like a mediation, the parties will talk together so the strike will not happen. Next. When in his opinion there exists a labor dispute causing or likely to cause a strike or lockout in an industry indispensable to our national interest, the Secretary of Labor Employment may assume the jurisdiction over the dispute and decide it or certify the same commission or compulsory or arbitration. Such assumption certification shall be effect automatically, enjoying the intended impending strike or lockout are specified in the assumption or certification order. If one has already taken place at the time of assumption or certification, all striking or lockout employees shall immediately return to work. The employers shall immediately resume operation, balik na sa normal, and readmit all the workers under the same terms conditions prevailing before the strike and lockout. The Secretary of Labor and Employment or Commission may seek assistance law enforcement agency to ensure compliance with this provision as well, such as orders as they may issue and enforce at the same time. Next, before or any at a stage of compulsory arbitration process, the parties may option out to submit their dispute to a voluntary arbitration. The Secretary of Labor and Employment Commission or the voluntary arbitrator shall decide to resolve dispute as case may be. The decision of the President, yun na. May other party nang sasama dito sa atin. The Secretary of Labor and Employment and the Commission or voluntary arbitrator shall final executory 10 calendar days after receipt thereof by the parties. Balik tayo dun sa nakalimutan ko sabihin. Okay na yung strike vote, guys, and then may 7 days observatory, mandatory to. Within the 7 days observed strike ban, ibig sabihin nun, reckoning point should be at the end of cooling period. Ibig sabihin nun, guys, balik tayo dun sa bargain and deadlocks, 15 days, dagdagan mo lang ng 7 days equals to 30 days. Pag unfair labor practice, 15 days. Add mo na ng 7 days equals to 20 days. Union busting, immediate na yun, di ba? So, 0 days, dagdagan ng 7 days. So, equals to 7 days, and it is. So, ganun nga, guys. Dito na tayo sa Article 264, Prohibited Activities. Before I go there, mandatory lahat yung requirements na yun, guys. Otherwise, magiging illegal na yun under this article. Dapat talaga mag-notice talaga kayo sa NCBA within 24 hours para hindi maging illegal, yun illegal na yun. Magiging prohibited na at illegal strike na tatatawagin. At meron pa, yung mga the union leaders will be dismissed and di maganda yun sa papel ninyo kasi nag-participate kayo at nag-commit kayo ng illegal strike, hindi maganda yun at dismiss kayo sa trabaho. Article 264, Prohibited Activities. No labor organization or employer shall declare a strike or lockout without first having a bargain collectively in accordance with the Title 7 of this book, or without having filed the notice required in the preceding article, or without the necessary strike or lockout vote first having been obtained and reported to the ministry. No strike or lockout shall be declared after assumption of jurisdiction by the President or the Minister, or the certification submission of the dispute compulsory or voluntary arbitration, or during the pendency of cases involving the same grounds for the strike or lockout. Any worker whose employment has been terminated will have a consequences of any unlawful lockout shall be entitled to a reinstatement with the full back wages. Any union officer who knowingly participate in illegal strike, any worker or union officer, yun na nga, sinabi ko nun, wag na ako nang sabihin to kasi sinabi ko na kanina, sinamari ko na. Okay. No person shall obstruct, impede, or interfere with the by force or violence, coercion, threats, or intimidation any peaceful picketing by employees, any labor controversies in the exercise of the rights of organization or collective bargaining, or shall aid or abet such obstruction or interference. No employer shall use, employ any strike breaker, nor shall be employed as the strike breaker. So, balik tayo dun. Ibig sabihin ng lockout, the meaning of lockout is any temporary refusal of an employer to furnish work as a result of an industrial or a labor dispute. Any picketing, I didn't put in the terms, so I will add it here. Picketing is the right of workers to peacefully march to a and to fro from before establishment involved a labor dispute generally accompanied by carrying display of signs, placards, and banners intended to inform the public about this dispute as well as their grievance. At yung parang, sige, recently, we have a transportation strike. Ito yung may placard, yung nakikita nyo natin sa news. Ganun na yun. Pinagko-combine na, combined with the strike and picketing to know to know the public what is happening to the dispute where they're in strike and picketing. Another one, I didn't add the term of strike breaker. Okay, the meaning of it, a person or any person who obstructs, impedes, or interferes by force, violence, coercion, and threats, intimidation, and in peaceful picketing affect the wages, hours, condition of work, or in any exercise of the right self-organization or collective bargaining. Next, D, under the article of 264, no public official or employee, including officers and personnel of new armed forces of the Philippines or integrated national police, or armed person shall bring in or introduce an escort in any manner. An individual who seeks to replace the strikers in entering or leaving the premises of a strike area work in the place strikers. The police force shall keep out the picket lines unless it actual violence or other criminal acts thereupon, provided that that's nothing happened shall interpreted to prevent any public officers from making any measures necessary to maintain peace in order to protect life and property. About that, ito na yung guys, dito na pupunta yung mga pulis. Yung mga SWAT team, para lang makita, dun sila sa area nilang, strike area nila, dun lang talaga dapat. Alam mo naman, emotion is the part of our human needs. Violence ang mangyayari kapag di rin ako yung gusto nila, magikinit ng ulo na. So, kailangan talaga may pulis doon at doon lang talaga sa area na yun. No person engaged in picketing shall commit of any act of violence, concern, or intimidation or obstruct the free ingress to egress the form employer premises for law purposes or obstruct the public thoroughfares. Para naman kaalaman sa lahat, ano ko lang yung strike area, tindihin lang natin ng konti. Ito yung establishment, warehouse, depots, and plants or offices, including the sites or premises used as runway, shops, or of employers struck against, as well as the immediate vicinity actually used by picketing strikers in moving the all points of the exit entrance from the establishments. So, lahat-lahat na, andun na. Naibahan na lahat. Now, improve over balloting. Before that, take note, very really take note that burden of proof to have a strike really need the union must or mandatory prove the compliance with requirements of the law. Bakit kayo nag-i-strike talaga? Mandatory talaga, guys. Wag basta-basta. So, moving on. Article 265 improve offer balloting. In an effort to settle a strike, Department of Labor and Employment shall conduct referendum by the secret ballot on an improved offer or employer on or before the 30th day of the strike. At least majority of the union members vote to accept the improved offer. The striking workers shall immediately return to a work. Employer shall thereupon readmit them upon the signing of the new agreement. In case of lockout, Department of Labor and Employment shall also conduct a referendum by the secret balloting on a reduced offer of the union or before the 30th day of the lockout. When at least majority of the board director or the trustees or the partners holding the controlling interest in the case of the partnership vote to accept reduced offer, the worker shall immediately return to work. Employer shall thereupon readmit them upon the signing agreement. Back to normal na sila. A new agreement of contract. Ano nangyari? In any case, from this, the strike, you achieve the strike of the goal, but some of the union members don't want to renew. So let me dip down in this thing. There will be a replacement or termination of employment status by any union officer who knowingly participate in illegal strike, and any worker or union officer who knowingly participate in the commission of illegal acts during the strike may be declared to have lost his employment status. Because they want more to it, they will be replaced. Moving on to the Article 226. Next. Article 266, requirement for arrest and detention. Except on the grounds national security and the public peace, or in case commission of crime, no union members or union organizers may be arrested, detained for non-union activities without the previous consultation with the Secretary of Labor. Yan. Datingan ng mga lawyers with the proof of anything there for arrest and detention. Now moving on, for the consideration of mediation. Conciliation mediation is a mode of dispute settlement that brings together two disputing parties to negotiate and settle their differences. It's a process of national, mythologically, and orderly, civilized, of the differences between the parties to a dispute under the guidance of a conciliator or /mediator. Ito yung galing NCBA. And sorry. Sorry for that. Napiyok ako. Okay. NCMBA. Yun yung mediator, conciliator, mediator. Yun na yun. Okay. Guys, gets yun na? To differentiate, the conciliation is a mild form or intervention by a neutral third party. The conciliator mediator relying on his persuasive expertise, who takes an active role in assisting both parties, trying to keep the discrepants talking, facilitating other procedural necessities, carrying the messages back and forth between the parties to keep things forward-looking in a situation. Mediation is an intervention through a conciliator mediator, whereby he starts advising the parties or offering the solution or alternative to the problems with the end view assisting them towards a voluntary reaching their own mutual acceptable settlement of dispute. Ito na yung, this is the part na renew of contract to stop the renewal of contract to their needs and goals of the strikers of the or the union members, what they're striking for. That's all. Thank you. And lastly, whew, the DOLE, through the National Conciliation and Mediation Board, NCMB, promotes a conciliation mediation as preferred mode of the resolution of the unfair labor practices, bargaining deadlock issues to prevent the notice of strike, lockout, and preventive mediation cases from maturing into actual work stoppage. In case actual work stoppage, conciliation mediation mode services continue to settle this dispute at the earliest possible time to prevent or minimize the effect the workers, company, and economy. Ito yung parang to get the common goal, to get the para hindi na para move forward tayo sa economy natin, para may trabaho yung mga tao at hindi mabawasan yung unemployment. Kaya nag-i-interfere ang NCMB para makuha yung dalawang party at mediate and may conciliation sila to get the common to the contract and read it thoroughly to them to be an acceptable settlement to both parties. Thank you for listening, guys. That's all. It's the end of my presentation. And this is my sources. I will give the PowerPoint to the Viber in any case with the link.